of the press. I will speak briefly on the issue of the rendition of Mazi Nnamdi Kanu from Kenya to Nigeria. We are all aware that Mazi Nnamdi Kanu, after the attack on him by the military of the Nigerian government, had to flee Nigeria for his life to Kenya. Unfortunately, in that attack in his hometown at Afaruku, so many people were murdered by the Nigerian military. Not less than 28 persons died on that particular day in the hands of the Nigerian military. And these are young men and women who had no arms on them, who were in a private compound of the late chief of Afaruku. After the attack on the property, killing people, the occupants, including Mazi Nnamdi Kanu, his parents, that's the traditional ruler of Afaruku, and the wife, had to flee, amongst other persons that managed to escape. But like we are saying, 28 persons died on that particular day. After that day, so many other people died, including the parents of Mazi Nnamdi Kanu. And this is as a result of the injuries, the shock that was inflicted on them by the Nigerian military that attacked the compound of Mazi Nnamdi Kanu. And the Supreme Court, in its judgment of 15 December 2023, has confirmed this position, that Mazi Nnamdi Kanu's escape was not an escape from justice, but rather was a natural action taken by a human being who is aware that his life is imminently in danger. He had to run away to save his life so as to be able to stand his trial in our courts. Mazi Nnamdi Kanu was eventually kidnapped from Kenya and brought back to Nigeria against every known law, both locally and internationally. They also showed very grave disrespect to the Kenyan authority and to the nation of Kenya. Unfortunately, the Kenyan government appeared to be docile about the breach of their territorial integrity by the security agencies of the Federal Republic of Nigeria, who came into their country and kidnapped Mazi Nnamdi Kanu. We strongly believe, just as the Supreme Court has also upheld, that what transpired in Kenya was an international crime. It is not just a civil matter, it is a criminal matter committed by the Federal Republic of Nigeria using its agents and agencies. The federal government of the Federal Republic of Nigeria, if it was a human being like myself and my colleagues here, ought by now to be in prison. Nigeria as a country, if Nigeria was a human being, ought by now to be detained in a very, very strong maximum security prison for committing the crime of kidnap. They are nothing less than Shekarau of the infamous Boko Haram. They are nothing less than the bandits that everybody is crying of today. The crime of kidnap is a heinous crime, it's a terrible crime, it's an uncivilized crime that ought not to be found within the shores of this country. But unfortunately, the federal government of Nigeria has participated in this crime of kidnap. Of course, we all know that the federal government of Nigeria attempted this kind of crime with Umaru Dikko. It failed, and they got punished for it. The perpetrators were sent to prison in England. Nigeria as a nation was also penalized by the Commonwealth, suspended from every Commonwealth activity. This is what we expect should happen to the Federal Republic of Nigeria today. It is our strong belief that those agents who were sent to carry out this infamous and inglorious mission ought by now to have been brought in, interrogated, and sent to the Ministry of Justice for prosecution. But unfortunately, we are asking the federal government that perpetrated it, that engineered it, to prosecute its own agents that it sent on this mission. Federal government of Nigeria sent people to Kenya to commit a crime of kidnap. They carried it out. Those individuals who committed this crime by now should be arrested and brought to book. Nigeria, like I said before, as far as we are concerned, until they purge themselves of this crime, remains a criminal country. It is unfortunate, it is our country, but that is the position. Until Nigeria purges itself of this crime of kidnap that it has committed against Mazi Nnamdi Kanu, remains a criminal country and ought to be dealt with in that fashion. Mazi Nnamdi Kanu committed no crime known to any law. Just because he's asking for self-determination for his people, which is supported by the African Charter, is supported by the United Nations Charter also on Human and People's Rights. It is supported by our Constitution. For this reason, he is being persecuted, not prosecuted. For the federal government of Nigeria to have kept him in detention in a solitary confinement for 3 years is persecution. There is no law supporting this impunity. There is no law supporting this illegality. There is no law supporting this breach of our Constitution. If somebody has committed a crime, according to our Administration of Criminal Justice Act, Section 169, such a person should be detained in a prison if you must detain the person. But in this case, no crime has been committed, no antagonistic move has been made against the Constitution. Every action taken by Mazi Nnamdi Kanu has the benefit of constitutional protection. Self-determination, calling for self-determination is not a crime. Asking for a referendum to determine whether this nation called Nigeria or this political arrangement called Nigeria should stand or not is a matter of his belief, something that ought to be discussed and agreed upon. Nigeria was amalgamated in 1914 under Lord Lugard, and under the influence of romantic relationship, the name Nigeria was ascribed to this part of the country or this part of the world. Our fathers, our ancestors did not agree to an amalgamation in the first place. Our ancestors did not agree to being named Nigeria. Our ancestors did not agree to surrendering their individual and community sovereignty, but this was obtained under the barrels of the machine gun and possibly under the influence of alcohol by Lord Lugard and his girlfriend. And today we are all suffering that consequence. We are all suffering that false unity. We are all suffering these political arrangements. We also all know and we also all agree that in Nigeria, this country today does not have a valid constitution that you can rely or call a constitution. The people of the Federal Republic of Nigeria, as we are called, or as we are being forced to bear, had never met one day to agree to have a constitution. So the preamble of the 1999 Constitution is based on falsity, based on lies, that we, the people of the Federal Republic of Nigeria, has given unto ourselves a constitution. We did not give to ourselves any constitution. The constitution is an extension of a decree of the military juntas that was in power at the time in question. It is not the intention of the people of the Federal Republic of Nigeria, as we are being forced to bear, to have that document as our constitution. But because we cannot continue to operate in a vacuum, we are managing it. And even in managing it, the federal government today has consistently refused to respect and obey its constitution, or I would say its so-called constitution. The Federal Republic of Nigeria, as far as we understand it and as far as we are concerned, does not have a binding law that holds us together. The arrangement is a military arrangement in all ramifications. Lord Lugard came with his machine guns to hold us together. The military came with their machine guns and bombs to force us to swallow a constitution, a document called constitution. So until the people of Nigeria comes together to decide whether they want to remain a nation, we cannot say that we have a nation. Now, some will say it is the National Assembly that has the powers to determine such. We beg to disagree on this. The National Assembly does not have the power because in the first place, the Constitution of the National Assembly is made from the false document called the 1999 Constitution. You cannot place something on nothing and expect it to stand. You cannot put, you cannot build a mansion on lies. The people of Nigeria today did not sit at any time to have a constitution. A decree, a military decree was made, and we were forced to take it and adopt it and accept it as our constitution. But ordinarily, I was not represented. People from my community were never represented in that constitution-making process. And I'm sure even members, no member of the public had their people in that constitution-making process apart from the military. So that constitution is a military constitution that we are being forced to operate. Mazen Nnamdi Kanu advocates for a situation where people, indigenous people, can come together and decide who they want to interact with. The document upon which Nigeria was forced upon, or was falsely created, gave Nigeria 100 years to determine whether it will continue in that manner or not. And our current situation is such that there is need for us to review that document. There is need for us to determine whether we want to continue as Federal Republic of Nigeria or not. If people want to have self-determination, if people want to live under their own rules and laws in accordance with their customs and their tradition, so be it.